very much. I recognize a lot of you here in person and some of the names online. But for those of you who I haven't met, my name is Adam PUGH. I'm with the law firm of PUGH. We focus on serving homeowners associations. We represent over 1,200 of you at this point. Our goal is to try to keep you out of litigation, keep you out of trouble, and point you in the right direction. The fact that you're here today means you're on the right track. We've got, I think, 5 or 6 sections today. We'll take breaks, and then those will be a great time to ask questions. If you do have questions and you're here and you're present, write them down so we don't forget them, and we'll address them. If you're online, use the chat function. Mitch will keep track of that and make sure that your questions get asked and answered. But otherwise, I think I'm just going to jump right into it. And we'll get started. So Mitch, if you'll select the presentation so I can have a little clicker.
Yep.
We'll be good to go. There we go. Well, there's me. That's about all you need to know about me right there. And we'll get started with association governed communities and governing documents. It's a good place to start. You'll probably hear me say this during the presentation a number of times today, but the best place to start is your governing documents. If you're on a board of directors, and you haven't read your declaration and your bylaws and all of the other policies that are on file in the county where you are located, go ahead and do that. That's going to be the best place to start and get you started on the right track. That's all right. All right, so these are the topics in this first section: common interest developments in Texas, associations of property owners for common interest developments in Texas, statutory laws that govern community associations, and then of course your governing documents. So first, let me talk a little bit about the vocabulary I'll use today so we're all on the same page. If I say homeowners association or HOA, I mean any residential property owners association that covers condos and subdivisions. Those are really the two categories. If I say condominium association, that's an association that administers condominiums. If I say subdivision association, that's an association that administers single-family residential homes. And here's another thing that I'll point out right now. Those are the only two categories. People ask me all the time, well, Adam, actually, that's not correct. We are townhomes, so we're different. Or actually, our association has garden homes in the name. So we are a different type of thing. It's just not true. You're either a condo or you're a subdivision in the state of Texas. And if you don't know which one you are, check your declaration. It probably says so right up at the top. All right. So let's start from the beginning. What are common interest developments? And why do we have homeowners associations? Are homeowners associations governmental entities or private corporations? So what are common interest developments? There are two basic forms of common interest developments under Texas law. You've got subdivisions and you've got condominiums. This is true regardless of what the development's called. Like I said, if it's a townhome, a garden home, whether the development is a subdivision or a condo is based on the real property ownership interests and not necessarily the architecture of the physical structures. And I'll give you some examples here in a moment. Now, the term subdivision generally refers to the division of a tract or parcel of land into 2 or more lots or other divisions of land for the purpose of sale or building development. And each lot is a separately owned, exclusively owned parcel of real property. Now, a subdivision development is generally created by the subdivision of a large tract of land into smaller individually owned parcels. And then you've got common areas that are going to be owned by the HOA, and then you've got streets. The biggest difference between a condominium association and a subdivision association is in a subdivision association, your entity actually owns the common areas. In a condominium, the owners collectively own the common areas in common. That's why on your deed, you'll see, unit 1 and a 0.25% interest in the undivided common area elements. That's how you know which one you're in. Give you battery, I think.
No, it's me.
All right. So here's an example of what you do at the subdivision. Take an undivided parcel of land. You file a subdivision plat, dividing the land into separate lots. You install the streets and utilities, and then you construct the houses on each lot for individual ownership. Condominium's a little bit different. This is a hybrid form of real estate ownership created by statute. It's a legal fiction that we came up with, and that's why it's a little bit more complicated than owning a home in a subdivision. You own your unit in fee simple ownership, and then you have a tenancy in common, which means an undivided pro rata interest of the common elements. A condominium development generally involves a single tract of land, although you can have multiple tracts, and the developer records a condominium declaration that designates portions of the space as units, and then other portions as general common elements and limited common elements. The units are to be owned by homeowners as separate property, and the remainder of the property is common elements proportionally owned by the unit owners. In a condo development, the unit owners own 100% of their units, and then a pro rata interest in the common elements, and the association doesn't own anything. It's important to remember that when we're talking about the association granting rights in parking spaces and other parts of the common area to the owners. The association is more like a trustee responsible for the maintenance of those areas and not the actual owner. There are two types of condo developments. We've got traditional condominiums and then what lawyers refer to as site condominiums. So the defining characteristic of whether a condominium unit is a traditional or a site condominium is whether it's a defined cubicle of space with the boundaries being things like the inside portion of the sheetrock and the top of the ceiling versus lines on the ground like a traditional lot. So here's one way you can form a condominium. You take an undeveloped tract of land, you file a condominium declaration designating portions of the land as units, and then the remaining portions of the land is the common element. You can also take that same idea and turn it vertical. You've got units defined as portions of the building, and then they're separated by floors and of course walls. That's a typical high-rise condominium, but it's not the only way that a condominium can be formed. You can also take an undeveloped tract of land. You can file a condominium declaration designating a portion of the land as units. You can define the unit boundaries as lines on the ground, just like a subdivision. Then you build a detached home within the boundaries of each unit. And then you construct the streets within the common elements. And so it looks just like a subdivision. All right, so here's a little pop quiz to get your brain working this morning. By looking, can you tell if that's a condominium or a subdivision? Exactly, you can't tell. How about this one? Is this a condominium or a subdivision? That's correct, you can't tell. How about this one? Is this a condo or a subdivision? This one you might be able to tell. This one's a condominium because you wouldn't know this, but each room within that building is an individually owned condominium. What gives it away is it's a vertical structure, and probably there's little cubicles of space in there. All right, so what are common interest developments in Texas? We've got subdivision and condo developments, and they are treated significantly different. It's always important to know whether your association governs a subdivision or a condominium. Now, most of the time, lawyers aren't trying to hide this from you. So take a look at your declaration. If you're a condo, I bet it's in the title. But if you're still unclear, look and see how a unit is divided. Look at your deed to see if you either own a lot and block within your neighborhood, or if you own a unit plus an undivided interest in the common elements. That's pretty much the easiest way to tell. Now, why do we have HOAs, Adam?
Related to condominiums, good question. What is a limited common element, and how does that factor into?
Sure. So limited common elements are kind of one of the most ambiguous areas in condominium ownership. It's pretty easy to know what a unit is. There's usually pretty good boundaries set up for what do I actually own. And then what are general common elements? That's usually pretty easy. The parking lot, the hallways, the streets in a site condo arrangement. But limited common elements are kind of this gray area. And you've got to look at your declaration to figure out what those are. There's not really a statutory definition of limited common elements that is a one size fits all. But in general, you're going to see things like patios that are limited common elements. A limited common element is any common element owned by all the unit owners, which is for the of less than all of the unit owners. So you can have limited common elements that are just for use by one unit owner, like a patio or a balcony, or you can have limited common elements that are to be shared by everybody on the same floor. In some of the high rises in downtown Austin, you've got limited common elements for each floor that they can use. And so it's going to be defined by the declaration. All right, so in a subdivision development, the subdivision owns the common areas on behalf of and for the benefit of lot owners. And as the owner of the common areas, the subdivision association is responsible for its maintenance. In a condo development, the association is charged with the duty to maintain and repair the common elements on behalf of all the unit owners, and the association acts as a pseudo trustee for the benefit of all the unit owners. So general rules for maintenance responsibility. Owners are responsible for maintaining their units in a condominium. The condominium association is responsible for maintaining the general common elements, but who is responsible for maintaining the limited common elements? The answer is you've got to look at the declaration. There's no general rule. In some instances, the association is 100% liable for the limited common elements. In some other instances, the unit owner is solely responsible and even has permission to make changes. But it's very important, again, to look at the declaration because, as I said before, there's really no universal answer to that question. Now, what is a homeowners association? Homeowners association is a private organization made up of lot owners in a subdivision and unit owners in a condo development. It is generally vested with the management and maintenance of the community and its amenities or common areas or common elements. Association governed communities are created by private agreements that usually take the form of a document entitled Declaration of Covenants, Conditions, and Restrictions. We usually just refer to that as the declaration. It's recorded by the owner of the property prior to development, the developer, also referred to as the declarant, in the official public records of the county where the development's located, and it runs with the land. That's just a legal term that means regardless of whether or not you sign a piece of paper or know about the declaration, you're bound by it. All you've got to do is accept a deed to the property, and now you're a party to the contract. The resulting effect is that the property becomes permanently subject to the declaration, much the same way property can become subject to an easement. Click back on the presentation. Thanks. Now, each homeowner who purchases a lot that is subject to a declaration is presumed to have notice of the declaration applicable to his or her property, regardless of whether they have actual notice. And they become obligated to comply with the contractual obligations simply upon acquiring ownership of the property. This is true regardless of whether the property owner was even actually aware of the declaration or not. We do a lot of collection work and violation enforcement work for associations, and a lot of what we do is education. I get a lot of phone calls from owners who say, well, I never joined your club, or I never signed anything, or I never agreed to be part of this association. Why are you even bothering me? Changing their view of the world usually takes a little time, but we get a lot of complaints that my realtor didn't explain this to me, or nobody told me when I was at the closing, and so half of what we do is education, and it's important to know that a lot of people out there don't understand how this works. They are first-time home buyers. They're not volunteering to be on the board of directors for their community because they don't even know where you would start. And so you have to understand that there's just different levels of information out there, and working with these people to make them good neighbors involves a little bit of patience and a little bit of education. Now, you've got the declaration. This establishes the association governed community, and it imposes land use restrictions on property within the applicable community. It provides for mandatory membership of all lot or unit owners in an HOA, and it vests the association with certain powers and duties over the applicable community and the homeowners that live there. In almost all cases, the HOA is going to be incorporated as a nonprofit corporation. There are still condominium associations out there that were created prior to January 1st, 1994 that may not be incorporated. But even those have generally made the decision to incorporate, to take advantage of some of the benefits of being incorporated through the Secretary of State. So almost all of your associations, I would guess, are incorporated, but there are still some out there that aren't. Incorporation as a nonprofit simply provides the structure by which your HOA is governed, and it makes it subject to Chapter 22 of the Business Organizations Code. Nonprofits are also governed by private agreements. You've got the certificate of formation, also referred to as the Articles of Incorporation. The only difference there is when the Business Organizations Code was codified to replace the Nonprofit Corporations Act, we started calling these things certificates of formation. They used to be referred to as Articles of Incorporation. If yours are articles, there's nothing you need to do. It's just, it goes by both names. Then you've also got the bylaws. We refer to those as the corporate documents. All right. In addition to the declaration and corporate documents, HOAs are governed by the property code and Texas Nonprofit Corporation Law, specifically the Business Organization Code, Chapter 22. That governs all nonprofit corporations, not just HOAs. Now, homeowners associations are governed by a bunch of different regulations, and this kind of illustrates all the various obligations you've got. So an HOA is governed by its declaration and the Texas Property Code. And pursuant to those documents, it's vested with the power to levy assessments and enforce the development restrictions. An HOA is also a Texas nonprofit corporation. So it's governed by its corporate documents, the bylaws and amendments of those, and Texas Nonprofit Corporation Law, Business Organizations Code, Chapter 22. It's a corporate entity vested with the authority to transact business authorized by the corporate documents. So you put that all together and you've got a Texas Nonprofit Corporation Homeowners Association. And so it's governed by the declaration and Texas Property Code and its corporate documents and Texas Nonprofit Corporation Law. But that's not even all the things you've got to be worried about when you're on the board of directors. This illustrates that we have a lot of cooperation and conflict between varying statutes. We'll talk about all those statutes later and the hierarchy of how to untangle that mess.
Adam, just for kind of visualization purposes, what would be something applicable, like an example of some of the stuff that's covered in the business code?
Sure. So the Business Organizations Code governs all nonprofits, and it's really a gap filler statute. So if you, for instance, haven't recorded your bylaws, or you just didn't have bylaws, or the last board lost them and you don't know where they are and they were never recorded, there's nothing to panic about. The Business Organizations Code replaces your bylaws with provisions that allow you to still conduct business. For instance, most of the time you will find what your quorum is to conduct business in your bylaws. But if you don't have bylaws, Chapter 22 of the Business Organizations Code says your quorum is 10%. So what it does is it fills in the gaps so that we can have a corporation that still has rules and can still conduct business, even if the folks that set it up might have forgot a couple of things.
There's also, I guess, something that we use to provide us guidance when COVID hit, and everybody went from, we used to have meetings in person to now virtual, and how do we do that? And absentee balloting and everything from that.
No, it's a great point. The Business Organizations Code does have some provisions in it that provide for these kind of emergent conditions and electronic meetings and those types of things, even if your association was formed well before electronic meetings were even an idea. So we can generally find a solution to most of our problems in these statutes that fill these gaps. So there are other laws that are applicable to HOAs as well. There's a number of federal and state statutes that govern HOAs. Such statutory laws govern the day-to-day operations of an HOA. We can rank them in hierarchical authority. The highest authority, of course, is federal law. Examples of federal laws that govern HOAs include the Fair Housing Act, the ADA, the Freedom to Display the American Flag Act, and there's rules that are promulgated by the FCC, which limit your ability to control where people put antennas and satellite dishes. You're probably familiar with the concept that your association may be able to tell people, hey, you've got to stick the satellite dish in the back. But if somebody tries to install their satellite dish on the back of the property and they can't get all the channels or they don't get good reception, they are permitted under federal law to ignore your rules and put it where they actually have access to those signals. So that's just an example of how federal law can supersede your governing documents. The next highest authority, of course, is Texas state law. Some of these laws include the Texas Nonprofit Corporation Law, the Business Organizations Code, chapters 5, 81, 82, and then 201 through 215, which all apply in varying ways to homeowners associations. We've got 551 and 552 of the Texas Government Code. Those are applicable provisions of the Open Meetings Act. You've got the Texas Community Homes for Disabled Persons Location Act and Texas Health and Safety Code. The first of those governs things like group homes and your ability to restrict those in your neighborhood. And Texas Health and Safety Code has a bunch of provisions that apply to pools and amenity centers. And then you've also got Texas's own version of the Fair Debt Collection Practices Act and the Fair Housing Act that also apply. Now, homeowners associations are also subject to the ordinances, codes, and regulations of the cities and counties where they're located. So it's important to remember those as well. So you've got Texas Business Organizations Code, Chapter 22, the Uniform Condo Act, which is codified as chapters 81 and 82 of the Property Code, and then Chapter 209 of the Texas Property Code. If you're a subdivision association and you haven't read through the entire Section 209 of the Property Code, it's not that long. I'd recommend at least reviewing the titles to each section in there and understanding how that operates with your governing documents. Now, the collection of private agreements that establish the powers and duties of an HOA are generally referred to as the governing documents. And those governing documents have a hierarchy of their own as well. So you've got the subdivision plat. That's the first document that will ever be filed with respect to your neighborhood. It is important that you have a copy of this and you've reviewed it. There are important notes on a subdivision plat with respect to development and the maintenance of certain drainage facilities and other items. A lot of times you'll find who's responsible to maintain the sidewalks on the plat. And these subdivision plat notes can supersede your declaration. It's also where you'll find language like the developer and or assigns will be responsible in perpetuity for certain maintenance obligations. Well, you're the assigns. The association is the successor in interest to the developer. Anything you find on a plat that's a developer's responsibility, it's going to end up being your association's responsibility. Next comes the declaration, then the certificate of formation, used to be known as the Articles of Incorporation. You can think of that really as the birth certificate of the association. That's how it springs into being. Then you've got the bylaws for the association and any rules and regulations promulgated by the HOA under its authority to establish those. So you've got association rules, you've got architectural guidelines if those are authorized, and that's the order of hierarchy, which just means if you've got a conflict between any of these documents, the one that is above the others will control. So the subdivision plat establishes the location of the lots, the common areas and the streets. It can also include easements that are imposed on lots, and it can also include development restrictions. The next highest governing document is the declaration. This is generally the most important document in your association. It's what you're going to refer to the most, and it establishes the HOA and it vests it with certain powers and duties over the applicable community and its owners. It's a private contract that runs with the land and imposes the contractual obligations that will apply to everybody. There's three types of these contractual obligations. The first one is obligation of mandatory membership in the HOA, the obligation to pay assessments to the HOA, and the obligation to comply with restricted covenants, also known as land use restrictions. The certificate of formation is also important. If the HOA is incorporated, which most of you will be, the next highest authority is the corporate documents. So you've got the certificate of formation, which you may not have ever referred to because what could be on there that's really important? I'd at least take a glance at it. The certificate of formation can include limitations on things like the number of board members, the way to remove board members, the type and kind of officers you've got. And a lot of times, when we go back and look at the certificate of formation, we find a conflict between the certificate and the bylaws. For instance, sometimes the certificate will simply state there shall be 3 board members. Then we go to the bylaws and it says you shall have 3 or more board members. And based on the bylaws, the association has increased the number of people on the board of directors. but that's in conflict with the Articles of Incorporation. The good news is it's pretty easy to amend the Articles of Incorporation unless you've got limits in there that require all the members to vote on it. But I would just encourage you to take a look, see if you find anything that conflicts with any of the other documents, because you might be surprised. After the certificate of formation, within the governing documents, you've got the bylaws, and a nonprofit corporation is formed when you record the certificate of formation. Some of you may have had to go through the process of reinstating your association. If you don't file the right forms and send the right postcards into the comptroller, you can forfeit your right to do business. If that happens, don't panic. You've got 3 years to fix it. And there's probably not a week that goes by in our office that we're not fixing something like that for an association. All right, the bylaws are the rules adopted by the nonprofit to establish procedures for its management and administration. In general, the bylaws are going to tell you things like the number and type of directors and officers, the election and removal of directors and officers, and calling and holding board and membership meetings. It's very common for declarations to authorize HOAs to adopt rules and regulations for the enforcement or implementation of the provisions of the declaration. Now, the rules include any guidelines, rules, policies, or practices adopted by the HOA under the authority granted to it by the declaration. I think this is a good time to mention this. About 10 or 15 years ago, there were a couple of lawyers, mostly in the Austin area, but all around Texas, that were giving the advice to homeowners associations that if you have the right to make and enforce rules, well, that just means you also have the right to fine the owners. That's just not correct. And the Supreme Court's answered that question several times. If you don't have the power in your declaration to levy fines, the ability to make and enforce rules is not enough to do that. So I would make sure that if you have a fine policy, if you're levying fines against your owners, that your declaration expressly allows for that. If it doesn't, give me a call, we can amend it, but it's probably not correct to keep on doing it. So association rules generally may be promulgated, modified, and or rescinded at the discretion of the board of directors. However, the rules may not conflict with the declaration, and they can't impose restrictions that go above and beyond those imposed by the declaration. So examples that I've seen are things like in the declaration, it says there shall be a 20-foot setback from the front of the house. And then the architectural committee gets together and goes, 20 feet isn't enough. Let's have a rule that says it needs to be 30. You can't do that. You can't make rules that impose more restrictions on owners than the declaration, which is filed in the deed records, imposes upon them.
I probably just add to this, I interact with boards all the time that very much want to put some rules together, right? They want to clean up or clear up some of the gray area. Best practice for doing that, board gets together, sometimes maybe informs a committee, goes through and tries to identify where the gaps are, and then comes to you with some of these bullet points to say, can we do it or not?
That's the way to do it. I mean, I think when you're making the rules, first and foremost, you need to understand what you're trying to do. You need to understand your objective. What are we trying to do? Are we trying to clean up the neighborhood? Are we trying to make it a little bit more family friendly at the pool? What are our goals? Then review the declaration. At least take a look at it. You might not understand all the provisions. You might not understand exactly what rules you can make, but at least take a look at the declaration and do your best not to conflict with it. Then write the rules out in just layman's terms. What are you trying to prevent? And then bring those to a lawyer to help formulate clearly written rules that aren't going to be ambiguous, that people aren't going to be confused about. Then we can get those filed in the deed records, posted wherever you need to post them, and make sure that they're enforceable and that you've got a mechanism for enforcing them. Even if you can't fine and you don't have the impetus in the neighborhood to go and amend the deed restrictions to allow you to fine, there's other ways to enforce deed restrictions that can be very workable. Not to say that fines aren't a good tool, they are, but there's other ways to enforce these deed restrictions that we can talk about. And each association has varying degrees of self-help remedies and other methods that we can use even if we can't fine.
And to be clear, same really applies to condos? In terms of being able to create
actually condos can fine no matter what. In Chapter 82 of the Property Code, And we'll get into this a little bit later, but chapter 209 is a limiting statute. It limits what subdivision associations can do. It limits their powers to restrict the use of land and what they can do to homeowners. Chapter 82 actually empowers condo associations and gives them rights that even if the declaration doesn't expressly state, you have anyway. So condos can find, HOAs have to look to their declaration for that power. And that's a big difference. And you stole my thunder, and that's okay.
Question.
Sure.
In your example of the fence with the 20 foot, you can't make it to 30 foot. If an exception is requested for 15 feet, who has the authority to grant that exception?
Depends. The architectural committee probably has that authority, but what you're talking about in that situation is a variance. The architectural committee can sometimes grant variances, but you've got to check your declaration. Normal language that you'll find in a declaration is, in the event of extraordinary circumstances that would inequitably restrict the use of the property, the committee can grant a variance. But you have to find those extraordinary circumstances, and it's not just we're giving out variances because we want to be nice. Some associations don't have the ability at all to grant variances, and then do it anyway and come to me to write it up and say, hey, we gave this guy a variance, we need to write this up and go ahead and get it on file. And then you look at your declaration and they don't have the right to do it. Sometimes you inform them of that and they say, yeah, but we've been doing it for years. Well, okay, I guess we need to talk. But you have to check your declaration. You may not have that power. That's not one of those things that just comes with being an HOA. That's a good question. Thank you. All right, HOAs derive their power and authority from their governing documents. This authority may be broad or specific, and it will ultimately depend on the express provision in those documents. So what are some best practices as leaders of HOAs? First of all, I would recommend that you read the governing documents. Secondly, I would recommend that you read the governing documents. Now, third of all, this one's important. You should read the governing documents. And then number 4, understand the governing documents. I'm really more concerned with 1 through 3, but 4 is important as well. And I would, if you don't understand the governing documents, ask some questions.
Also makes for a great sleep aid if you start reading them before bed.
Yeah, there's a reason there's not a lot of HOA. Even for us, it's not all that much fun to read those documents. All right, so that brings us to the conclusion of chapter 1.